4lawnotes.com presents AFSCME versus AIG Incorporated, a case note summary. So what happened? The American Federation of State, County, and Municipal Employees, a large public service employee union that had a large number of shares in AIG, the defendant, through its union pension plan, had submitted a proposal to AIG for inclusion in the 2005 proxy statement. The proposal would amend the bylaws for AIG to publish the names of shareholder-nominated candidates for director positions with any candidates nominated for the AIG Board of Directors. Under the SEC rule, AIG must include shareholder proposals in the proxy statement, and AIG excluded this proposal based on an exception for the proposals related to an election for membership. Therefore, the union brought suit in order to compel AIG to include that in their materials. And this went to federal district court, who denied the injunction and dismissed the case. So what's the issue? Does a shareholder proposal relate to an election if it seeks to amend bylaws to establish a procedure by which certain shareholders are entitled to include the proxy statements their nominees for the boards of directors? So the holding was, the Court of Appeals held that the union proposal could not be excluded from the proxy materials on the basis that the proposal relates to an election, and that the interpretation of the rule that the SEC advanced through its amicus brief, which conflicted with the SEC's prior statement that had been consistently applied for 16 years after the rules had been substantially revised, did not merit the usual court deference to agency interpretation. So the rule is, a shareholder proposal does not relate to an election under the SEC's rules for exclusion from a proxy statement if it seeks to amend the corporate bylaws to establish a procedure by which certain shareholders are entitled to include their own board of director nominees. 4lawnotes.com, presenting AFSCME v. AIG Inc., a case note summary, more available on our website.